Hey everyone, Chris Archer here. I wanted to take some time today and talk to you about a question that comes up in divorce cases or any case for marital dissolution or marital litigation, and that is division of property, assets, and debts. And so, as you may be aware, if you're going through a divorce in South Carolina, the court has the jurisdiction to divide the assets and the debts between the parties. And so it's important to understand what assets are included in this division. So, what is marital property? What is marital debt? And the general way of looking at this is on a timeline. So, marital property is going to be defined as any property that is acquired from the date of the marriage until the date one of the spouses files for marital litigation or files for a divorce. And so any property or debt acquired during that time period is going to be subject to division by the court. And each party acquires, just by virtue of being in the marriage, each party acquires an interest in any property obtained during that time, with a couple of exceptions, which we'll talk about in a minute. But it's important to understand that regardless of how legal title is held or where the property comes from, which spouse acquires it, if it was acquired during the marriage, then generally speaking, it's going to be considered marital property and is going to be subject to division by the court. So a couple of exclusions that we'll talk about. One is any property that is acquired by inheritance. So if you receive a sum of money, if you receive property, or anything else by devise or by will or by inheritance in any other way, then that property, so long as it remains separate from any other marital property, will not be subject to division by the court. And so if you were to receive a lump sum of money, let's say $10,000 by gift or by inheritance, it's important to keep that money set aside in a separate account so that we can track it. Because if that money goes into an account and gets commingled with marital money, say your joint banking account, then it could be what we call transmuted into marital property and then subject to division by the court. So it's important to keep any inherited monies divided or separate and apart from the marital funds. The second thing that's not going to be considered marital property, the court will not have jurisdiction to divide any property that is acquired before the marriage. And this goes into what I was saying in the beginning about the timeline of when the marital estate looks back to, and that's the date of the marriage until the date someone files. So any property that you acquired prior to the marriage is not going to be subject to division by the court. Additionally, any property that you obtain in exchange for the non-marital property that I just described is going to be excluded. So if you inherit $10,000 and then take that $10,000 and exchange it for a vehicle, say, then that vehicle would also be considered non-marital property. Similarly, if you owned property prior to the marriage and you convert that property into something new, say $10,000 cash that you had in a bank account prior to getting married, and you take that same $10,000 and use it towards the purchase of a car, then that vehicle also is going to be excluded from the marital estate. Third, any property that is excluded by agreement between the parties. And so this can be a prenuptial agreement, this can be what we call an antenuptial agreement, but if the two parties contract with one another to exclude certain items of property from the marital estate, then the court is going to honor that, so long as both parties entered into the agreement voluntarily, they were represented by independent counsel, and there was a full financial disclosure prior to the parties entering into the agreement. So if both parties want to exclude certain properties from the marital estate, they're able to do so, but we need to make sure that it's a fully voluntary process and that both parties know the the finances of the other spouse before agreeing to enter into any sort of contract like that. Lastly, any increase in value of non-marital property is generally going to be excluded. And one of the places we see this most is with real estate and it appreciating. So if you own a property or a house prior to the marriage, and that property increases in value, generally that increase in value, although acquired during the marriage, is going to be excluded from the marital estate. Now, there are some exceptions to this, especially if the spouse is contributing to that increase in value. But if, for example, this is just a piece of raw land sitting somewhere and you're not doing anything to it, it's fully paid off prior to the marriage, and its value simply appreciates because of the market or whatever else, then generally that appreciation, although again acquired during the marriage, is going to be excluded from the marital estate. So good things to keep in mind. What the marital estate is. The courts do not have jurisdiction to divide anything that is not a part of the marital estate. So oftentimes we get into disputes about what items are going to be included and what is not going to be included. But just as a general rule of thumb, any property acquired during the marriage until the date someone files for marital litigation is going to be included, with the exception of those items that I just listed to you. If you have any questions about marital estates or what property may be included or not included, feel free to give me a call at the office. I'm happy to answer questions. If I can't help you, then I can certainly point you in the direction of somebody who can. Take care.